Thank you very much to all of you for coming to listen to discussion about Hopcraft, and it's nice to see so many familiar faces. I apologise to those who I didn't recognise at first. In paragraph 54 of its judgment in Hopcraft, the Supreme Court said that, and these were its words, the decision of the Court of Appeal came as a shock to the car finance industry. And that is a fair assessment of the Court of Appeal's decision. Those of you who occasionally go onto YouTube will have been assaulted every time you went on by a series of ads which invited you to apply and make thousands of pounds. All you had to do was put in a claim, as long as you'd at some stage bought a car on some sort of finance, and you were guaranteed a very substantial return. And that was true. That is what would have happened on the back of the decision of the Court of Appeal. The ambulance chasers, if you'll excuse me calling them that, were rubbing their hands because Christmas really had arrived early. I mean, you could just be sure that you were going to get money for reasons we were going to discuss. So it did come as a shock to the car finance industry. But that wasn't the only reason that the case matters, or mattered to those involved. One had a sense of how important it was by having regard to the number of people who tried to intervene in the case. Firms from all over the country who hoped to put together a book of claims from anyone who's ever owned a car. The Treasury tried to intervene, and a number of other people, because it had serious implications for the economy as well. Perhaps understated in the media because people didn't want to alarm anyone. Just to put the appeal into context for a moment, the payment of commission in the car finance market, which is what the case was about, had actually been established practice for some 75 years before the Court of Appeal made its decision. Until recently, it had never been suggested that payment of a commission in those circumstances constituted a bribe. The main impetus to make that argument, that commission constituted a bribe, came in 2022 when the Court of Appeal decided a case called Wood and Commercial First Business Limited. That was not, in fact, a motor finance case. It actually concerned mortgage brokers. But in that case, Lord Justice David Richards suggested that liability for bribery may arise if the recipient of the bribe was required to act in a disinterested manner, something which came to be labelled as the disinterested duty. And that's a phrase one needs to keep in mind because it was the key issue which arose in the Supreme Court. That identification of a notion of a disinterested duty encouraged the thought that something short of a fiduciary duty might be sufficient to access the special remedies for bribery. As a result, soon after Wood, a very large number of cases were commenced in the county courts, contending that the payment of commission by a lender to a car dealer for introducing business to it constituted a bribe, absent the informed consent of the customer. And again, the notion in the Court of Appeal was that the basis for saying a duty was owed which had been breached was the suggestion that a car dealer, we're talking about used car dealers here, owed something just short of a fiduciary duty, called a disinterested duty, to punters who came in to buy cars. And you only have to think of that for a minute to realise that something was going seriously wrong. Be that as it may, in light of all the claims which had started in the county court, county courts produced decisions going one way or the other, sometimes in favour of the customers and sometimes in favour of the car dealers. But the consumers, the customers, won comprehensively in the Court of Appeal in 2024. In that case, the Court of Appeal held, essentially applying the Wood decision for which David Richards was responsible, that it is irrelevant whether car dealers are fiduciaries because the disinterested duty is sufficient and that car dealers did owe that duty to their customers in relation to the financing element of the transaction. That meant that customers were entitled, and again one needs to kind of think about what's being said here, it meant that customers were entitled to rescind the contracts, which they may have entered into any number of years ago, by which they acquired the cars and by which they borrowed funds. They were entitled to rescind those contracts and obtain a money remedy in the amount of the bribe without having to show that the contract had resulted in any loss. So you don't have to show that you lost money. You didn't actually have to show that you relied on any misstatement or any belief that the person dealing with you was a fiduciary. You just had to say, I bought a car, I was not told about the commission, any amount that the car dealer got by way of commission is now mine, and I can set aside the contract whereby I bought the car and obtained finance, return the car, subject to certain remedies, and get my money back. I mean, that is insane with respect. The Court of Appeal's approach also meant that such claims could be advanced, as I say, with minimal factual investigation, since the entitlement to the remedies awarded by the Court of Appeal did not in practice require anything beyond the bare fact of an undisclosed commission paid by a lender to a car dealer. So no dishonesty, nothing. No reliance, no loss. You just had to say, I bought the car, I wasn't fully told about commission. Now, we were not involved, by we I mean Niranjan and I, were not involved in the Court of Appeal. And we were brought in at the PTA stage in the Supreme Court in the autumn of 2024. The Supreme Court, once we put in the PTA application, granted permission to appeal in a matter of days and listed an expedited hearing for April 2025. And in fact, it was only April 25 rather than February 2025, because no one had availability to do a hearing for February 25, which was treated unbelievably urgently and rightly so. We'll, of course, discuss the judgment in more detail, but it's perhaps worth mentioning one point at this stage. As you'll have seen, one issue in the Supreme Court was whether the tort of bribery existed at all. And you might think it is surprising that this issue arose at all, because it had been around and never been questioned since, I think, the 1950s. Indeed, the Supreme Court described our submission that it didn't exist at all, this is at paragraph 139, as they said, an interesting if bold argument. And I can certainly see why they characterised it as bold. The truth is it was correct as well. Maybe we won't go into that. But there were two reasons why we nonetheless raised the point, despite it being, leave aside whether it was correct or not, despite it being interesting and bold. One reason was substantive and the other was tactical. The substantive reason is that if one looks at the historical evolution of remedies for bribery, it quickly becomes clear that they all have their origins in equity, not the common law. And for a long time, it wasn't possible to obtain any remedy for bribery, whether in equity or at common law, unless the recipient of the benefit owed a fiduciary duty of loyalty. And that rather makes one wonder why you need the common law claim at all. And just to be clear, the point that we were making is that the remedy of bribery was really a response to someone breaching their fiduciary duty, and indeed breaching the two core elements of the fiduciary duty, of not allowing the fiduciary to have a conflict of interest and not allowing the duty to make a profit from being a fiduciary. That all makes sense in the context of dealing with fiduciaries. What actually happened, though, in the 1950s was that that very simple response to a breach of fiduciary duty was then turned into a common law tort. And that's where things started going wrong, because it doesn't fit in a tort claim, because necessarily, at its core, it's a response to a breach of fiduciary duty. I'm not going to go into the detail of this beyond what I already have, unless you want us to, but the benefit of raising the point, although it was wrongly rejected, is that it reinforced our submission that even if the tort of bribery does exist at common law, a fiduciary duty of loyalty is an essential element of it. And that's the point we really wanted to get across. And the Supreme Court accepted that contention, which in turn meant that customers couldn't succeed without establishing that the car dealers owed them a fiduciary duty. And that's all I'm going to say by way of introduction. And Niranjan is then going to give you an overview of the Supreme Court decision.
Thank you, Laurie. By the time we got to the Supreme Court, it's fair to say there were probably 5 main issues in play. The first issue is the one Laurie's just referred to, the interesting if bold argument. Does the tort of bribery exist? Second, if it does, is a fiduciary duty of loyalty an element of it? In other words, is it a precondition for liability for bribery that the recipient owed a fiduciary duty of loyalty? Third, if it is, what is the test for determining whether there is a fiduciary duty? Fourth, applying that test, are car dealers fiduciaries? And fifth, what remedies are available for bribery? Now, I'll run through those quickly. On issue one, it was never likely that they would accept that the tort of bribery does not exist, not merely for analytical reasons, but also because of the impact it might or might be perceived to have on other areas of the law. But in the event, they gave two main reasons for rejecting the argument. The first was the grounds we were advancing for contending that there is no tort of bribery, the Supreme Court said, are purely conceptual or analytical grounds, and we hadn't identified any practical or policy problems with the existence of the tort of bribery. And they said that matters because if you're seeking to overturn a rule or principle that has stood the test of time, that's been around for a long time, the mere fact that there are conceptual difficulties is insufficient. I mean, it's fair to say Laurie and I had a similar experience in the Sequana case, where we were, I'm afraid, making another interesting, if bold, argument, this time that the duty to consider the interests of creditors upon insolvency or threatened insolvency does not exist. And the Supreme Court said there are problems with the rationalization of the duty, but it's been around for a long time. It's not a bad thing for it to be there, and it's pretty much the same thing in this context. The second reason they gave, and one can have a debate about how far this point really goes, is the need to deter bribes and bribery, and that is a reason why you want to keep the tort of bribery rather than get rid of it. But that meant the tort of bribery stays, and then the battleground shifts to issue 2, which is what are its elements. The Supreme Court began by making what I think is an important point, and it's right, that there's nothing inherently objectionable about paying somebody money with a view to achieving some result. So what is objectionable about a bribe is not the fact that a payment has been made, but the fact that making the payment is a means of procuring the recipient to act disloyally. And if that's right, if that's the right analysis of what makes bribery objectionable, it follows axiomatically that unless there is a duty of loyalty to begin with, the payment can't be a bribe. It might be in the popular sense of the term, but it's not in the sense in which the law has used it. And that in turn means that liability for bribery is not engaged unless the recipient owed a fiduciary duty of loyalty. The Supreme Court also pointed out that this means that the law avoids a problem that would otherwise arise, and the problem is this. So you'll know that in 2014, in a case called FHR, the Supreme Court held that if a bribe is paid, then the remedies available for it are not merely personal but also proprietary. So the recipient of a bribe holds the bribe on constructive trust for the claimant. But if you look at the reasoning in FHR, what gave rise to the constructive trust was a rule of equity, or two rules of equity, both of which require the existence of a fiduciary duty of loyalty. One of the rules was the no-profit rule, and that requires a fiduciary duty of loyalty. So if, as the claimants were contending, and as Wood, on one reading of it, had held, you can have liability for bribery in the absence of a fiduciary duty of loyalty, then there would be no proprietary remedy, and that in turn would mean that the availability of a proprietary remedy for bribes would vary according to whether the recipient of the bribe owed a fiduciary duty of loyalty or a disinterested duty that falls short of a fiduciary duty of loyalty. And as the Supreme Court pointed out, there is no trace of any such distinction, despite bribery having featured in the law reports for 200, probably closer to 300 years, which itself suggests that you do need the fiduciary duty of loyalty. And then the question was, what gives rise to a fiduciary duty of loyalty? What's the test for determining that? That was issue 3. And Laurie is going to address this in more detail. But in a nutshell, what they said was that the characteristic nature or feature of a fiduciary duty is the duty of undivided loyalty, and that must be expressly or impliedly undertaken. So I must agree, albeit objectively, to act altruistically rather than in my self-interest. Otherwise, I can't be a fiduciary, leaving aside some anomalous exceptions which don't matter for present purposes. That then took us to issue 4, which was the most important issue in the case, namely applying that test of express or implied undertaking. Do car dealers expressly or impliedly agree to undertake altruistically? Now, when I put the question like that, you might think it answers itself, and the Supreme Court did as well, because they said that car dealers never stopped being self-interested salesmen. There isn't a moment on the forecourt, as it were, when the relationship is transformed from self-interest to altruism. And that meant that car dealers aren't fiduciaries, and that in turn meant that the claimants could not access remedies for bribery, which meant that issue 5, what are the remedies for bribery, is actually academic. But the Supreme Court rejected our contention that the automatic entitlement to a money claim, which is what you currently have, you currently don't need to prove if a bribe has been paid, that it caused any loss, or even that the defendant was enriched by the payment of the bribe. You can simply get, by making a claim for it, a money judgment in the amount of the bribe, because there's an irrebuttable presumption that it constituted a loss or a gain, depending on how you rationalize it. But the Supreme Court upheld that aspect of the law relating to remedies, again, partly because they took the view it's necessary to do it to deter bribery. Now, the final point I want to make by way of overview is that although all the common law claims failed for the reasons we have identified, as you'll know, one of the claims under the Consumer Credit Act succeeded, namely that of Mr. Johnson. I won't spend too long on this because we're proposing to focus today on the common law claims. But it is fair to say that the CCA claims are also fact-sensitive, and that the fact that Mr. Johnson's claim succeeded doesn't mean that other claims will succeed or that they won't succeed. It just depends on the facts. But what is of some assistance is that the Supreme Court identified some factors that are relevant to the assessment of fairness under the statutory test which applies under the Consumer Credit Act. And they include the size of the commission relative to the charge for credit, the nature of the commission, is it discretionary or not, any failure to disclose it, the degree of sophistication of the customer, and any failure to disclose other relevant facts. For instance, on the facts of Mr. Johnson's case, a commercial tie between the lender and the dealer which wasn't disclosed. That's all I wanted to say by way of overview.
I'm going to now sort of say something about the key practical implications of the Supreme Court decision, but before I do, it's just worth pausing for a moment to think about the tort of bribery. So you plainly have a remedy in respect of bribery inequity. Tort of bribery is a common law remedy. The reason we were saying in a submission that wasn't accepted that you needed to reconsider the tort of bribery involved, among other things, the following. For a tort of bribery, you don't have to prove any dishonesty at all. You don't have to prove any negligence at all. You don't have to prove, if you're the claimant, any reliance at all. You don't have to prove any loss at all. Notwithstanding that, and I'm sure some other things that you don't have to prove, the common law gives a remedy. Now, compare it to fraud. Even in a fraud case, you have to prove reliance, you have to prove dishonesty. You're dealing with dishonest people with fraud. And you can see why the law would come down hard in the context of fraud, but they still require you to prove reliance and loss and dishonesty. None of that in respect of the tort of bribery. There's something very odd about it. It's why bribery is such a powerful weapon to use at the common law. Now think about this. If it's tethered to a breach of fiduciary duty, then at least you have to find fiduciary duties exist. If it's untethered to a fiduciary duty, and all you have to do is to establish some disinterested duty, which I'm going to talk about in a moment, you have the most powerful remedy in the world, which is available in the most absurd situations. And that's really what lay behind our suggestion to the Supreme Court, that something had to give in relation to the tort of bribery. I mean, fundamentally, we were saying it shouldn't exist at all. And it's not just me sort of fighting yesterday's battles. If you look at the law relating to how this developed, it's pretty obvious that a mistake was made in the 1950s. It's absolutely blindingly obvious. But for policy reasons, and one understands the policy reasons, and we always thought that the policy reasons would probably mean we wouldn't succeed, the Supreme Court said, well, we're not going to touch that. But what they might have touched, and again, they didn't do it for policy reasons, is the notion that you can get a remedy in the tort of bribery even when you suffered no loss at all. In common law, this isn't a fiduciary, an equitable remedy. At common law, you get a remedy without suffering any loss, without any reliance at all, without any dishonesty. Again, that seems a little bit odd. Anyway, key practical implications of the Supreme Court decision. It's fair to describe that decision as one of the most important that the Supreme Court has given in recent years, because it will influence a number of different areas of the law. I'm going to focus on two key implications for the law relating to fiduciary duties and as a consequence for motor finance cases. So far as the law relating to fiduciary duties is concerned, it's been unclear for many years precisely when a fiduciary duty arises, and anyone who's ever had to try and work this out by looking at authorities will understand what I mean. You have different decisions pointing in a number of different ways, and there have been a number of different formulations in the authorities, each of which emphasizes a different element of the test. For example, some formulations suggest that the putative fiduciary must objectively have undertaken to act in the interests of the beneficiary to the exclusion of their own. So a duty of self-interested, absolutely undivided loyalty. You have no interest in this at all. The only person whose interest you take into account is the principal. Other formulations, however, had suggested that something less than this was sufficient. For example, that the defendant played a role in the decision-making process of the claimant, and that the claimant was vulnerable or otherwise relied on the defendant. So there's some formulations which suggested vulnerability, reliance, as long as someone took what you said by way of advice into account, that was enough to give rise to fiduciary duty. And unsurprisingly, the claimants in the Supreme Court adopted that latter formulation, which principally derived from the judgment of Lord Justice Christopher Clark in a case called Novaship. The Supreme Court categorically rejected that soft test, if I can put it that way, and it did so for two main reasons. The first is that the claimant's test would prove too much. If it were the case that anyone who plays a role in the decision-making process of the claimant, I'm going to repeat that. The first is that anyone who plays any role in the decision-making process of the claimant is a fiduciary. Then, for example, a sommelier in a restaurant would be a fiduciary. They know things that you don't. They know what wine they have downstairs. And for most of us, at least, you go into a restaurant. I know there's some people in the audience who know something about wine. The sommelier says, get this wine, it's a good one. You say, okay, fine, how much does it cost? But you're absolutely dependent on their knowledge, and you absolutely, what they tell you has a role in your decision-making. Is a sommelier really a fiduciary? Obviously not. You go into an Apple store, and you say to the salesman, which phone is the good one for me? And they give you advice. I mean, these examples just kind of prove why this is ridiculous. Is the salesman in an Apple store who's giving you advice your fiduciary? Because they certainly play a role in your decision-making. They certainly know a lot more than you about the products. But that's where the law had just about arrived at. And those were examples we gave in the Supreme Court, and the Supreme Court accepted that would indeed be the logical consequence of adopting the claimant's test and indeed the approach taken in the Court of Appeal. The second problem with the claimant's test is that it was unprincipled. The Court pointed out that it was established by a long series of authorities that the reason why fiduciary duties are imposed by equity is that the fiduciary has undertaken to exclude their self-interest and act in the interest of the beneficiary. And that is fundamentally what a fiduciary is about. But that undertaking must actually exist. It's not imposed by equity. And again, just pausing there, you have to be able to find in your inquiry as to whether there is a fiduciary that there had been an express or implied undertaking of utmost loyalty. But the way in which the law had begun to develop was for people to say, oh, this person's vulnerable, that person relied on you, that person affected your decisions, therefore we're imposing a duty of utmost loyalty, therefore you're entitled to the remedies of bribery and other remedies. It had gone seriously wrong. There had been a lot of confusion. But the Supreme Court in this case basically cleared that away and made the point that the undertaking must actually exist. You must be able to find, either expressly or impliedly, an undertaking of utmost loyalty. And it's that undertaking, voluntarily given, which then generates the no conflict and no profit rules that are quite characteristic of the fiduciary obligation. So the court held in clear terms that a fiduciary duty could not arise, not just in motor finance cases, but more generally, unless the fiduciary expressly or impliedly undertakes to act solely in the interest of the beneficiary and to the exclusion of their own. And you will find that, for example, in paragraphs 90, 100, 108, 109 and 201. And the court has also held that in a commercial context, the general rule is that a commercial party will not have undertaken to subordinate their own interests to those of another, and that's at page 110. Now, that is a very significant decision, because this now represents the test to be applied in any case in which the court has to decide whether someone is a fiduciary. And that's the real significance of Hopcraft. Obviously, it has a relevance, and a big relevance, to motor finance. But it has a relevance across the board, because I can promise you what would have happened. Motor finance would have been first, but there would have been any number of other industries in which there was any kind of credit lending which would have followed. And that's really what everyone was worried about. And that's why, from that point of view, the test that the Supreme Court laid down is very consequential, because it's going to stop that bandwagon rolling. So the second practical implication of the judgment actually does concern motor finance. The judgment makes it very difficult for claims of this kind to succeed in the future, leaving aside the Consumer Credit Act issues, which we're not proposing to discuss. But the common law claims are very difficult in the light of the judgment, because what the Supreme Court did was to identify certain typical features of a car finance transaction, and it then found that those typical features are not sufficient to give rise to a duty of loyalty. And this is obviously not just motor finance, it applies to any credit lending industry. Those typical features, which again will not be enough to trigger a fiduciary duty and then bribery remedies, included the existence of an element of dependency on trust and confidence. So it's clear that the customer's lack of sophistication is not enough to give rise to a duty of loyalty, nor is the fact that they trust the dealer. As the court put it at paragraph 108, a relationship of trust and confidence is the consequence, not the cause, of a fiduciary duty. The typical features identified by a court, again, typical features which will not give rise to a fiduciary duty, also include statements by the dealer that they'll find the most suitable package or the best available deal. And again, that's, you walk into Apple, that's what they're going to tell you as well. That's obviously not enough to give rise to, I don't have a problem with Apple, I like Apple, but it's not going to give rise to a fiduciary duty. And they held that statements of that kind are not sufficient to give rise to a duty of loyalty, because there is a difference between agreeing to find the best deal and agreeing to act altruistically, and what is required is the latter. So while it is, of course, not impossible for a car dealer to be found to be a fiduciary, in the general run of cases, that is unlikely to happen. Niranjan is now going to deal with other potential consequences of the decision.
There are many other potential consequences. I'll identify 3 or 4 if we have time. The first concerns the impact that the judgment is likely to have on other credit brokers, that is to say, outside the context of motor finance. And I mention that because a distinctive feature of the motor finance litigation is that car dealers are not merely brokers, they're also selling cars. Indeed, that is the purpose of arranging finance. In this, car dealers differ from independent brokers who are not seeking to sell anything to the customer or provide any product to the customer. They are engaged solely to find for the customer a product or service, for example, a mortgage broker or an insurance broker. So to put it in the terms that were used in argument in the Supreme Court, those brokers wear one hat, whereas car dealers wear 2. And the question is, does it make a difference that you wear 2 hats rather than 1? Now, before Hopcraft, the law seemed to be moving towards treating independent credit brokers as fiduciaries. For instance, cases like McWilliam, Herstanger, and indeed Wood itself, although Wood can be distinguished because the contract said in terms that you would act for and on behalf of the claimant. But certainly Herstanger and McWilliam are cases in which you have an independent broker whose only job is to find you a deal, and often they say, I'll find you the best deal. And the law seemed to be saying, if you do that, you can't take a commission, and if you do, that's a bribe. Now, the Supreme Court in Hopcraft did not need to decide whether these other cases were correctly decided. But the reasoning in those cases may need to be revisited in the light of what the Supreme Court said in Hopcraft. That's because at para 110, and at para 10, there are two passages where the court deals with it. So at para 10, the Supreme Court said, an independent broker is not, quote unquote, without more a fiduciary. And it seemed to suggest that an independent broker can become a fiduciary on particular facts, but only if those facts are sufficient to give rise to, quote unquote, a necessarily implied no conflict duty. So that suggests that the test is one of necessity. So unless the product or service provided by the broker could not be provided without the existence of a no conflict duty, it may be in the light of Hopcraft that an independent credit broker would not be a fiduciary. For instance, if I go to a broker and say to him, I want a life insurance or a health insurance policy, and they say to me, that's fine, I'll find you the best possible deal in the market after looking at all possible options for you, and they give me something, they may well have a contractual obligation to use reasonable endeavors, or possibly even in fact to find me the best product. They may be liable for misrepresentation if they say so they'll do something and then they don't. But promising to get you the best possible deal is not the same as promising to put my self-interest aside. It is conceptually possible for me to recommend to you the best possible product, which happens also to be the product which will get me the greatest commission. The two could converge, and if they do, it's possible in the light of Hopcraft that there's no remedy for bribery. But it's an open question because the court did not need to decide it and did not decide it. And when you look at the section of the judgment which applies the law to the facts of the motor finance cases, the court did rely on the fact that car dealers wear two hats, which might be thought to suggest that if you don't wear two hats, then it's easier to find that you're a fiduciary. So that's the first point. What impact might it have on other credit brokers? The second point is the potentially increased scope for restitution for wrongs, a very difficult area of the law, in some respects made even more difficult, and I'll explain why I say that. So as we explained earlier, the Supreme Court rejected our contention that the automatic entitlement to a money judgment in the amount of the bribe is unprincipled. And the basis on which we advanced that argument was you can't rationalize that either as a damages remedy for tort or as restitution for unjust enrichment. As to the latter, in part because there's no unjust factor and also because there's a contract, and normally you can't get restitution for unjust enrichment unless you set aside the contract. Now, the Supreme Court avoided these problems by saying that it is the ability to get a money judgment in the amount of the bribe is to be rationalized as an instance of restitution for wrong. So you don't need an unjust factor, and the existence of an underlying contract is irrelevant. And at para 150, the Supreme Court seems to articulate as a general principle that if the defendant receives money as a result of a tort, then the claimant can elect for either a loss-based remedy or a gain-based remedy. Now, in rationalizing the bribery remedy as restitution for wrongs, the Supreme Court has potentially made inroads into existing limitations on the ability to obtain gain-based remedies in tort. There is a school of thought that you can only get gain-based remedies for tort if the tort in question is proprietary, for instance, intellectual property infringement. But that is difficult to reconcile with Hopcraft because the tort of bribery is, of course, not proprietary. So it has potentially wide-ranging implications for the law of tort more generally, including the tort of deceit, as to which there's existing court of appeal authority that you can't get gain-based remedies, a breach of competition law, and so on, and all of that remains to be worked out. Third, civil fraud and bribery claims. The importance of the judgment is attributable to a point Laurie made earlier, which is even in a normal case, that is to say not involving motor finance or any other kind of credit broker, but just an ordinary civil fraud claim, you can't access the special remedies for bribery unless you have established that there is a fiduciary duty of loyalty, as opposed to something short of that. Now, in many cases, this won't matter in practice because the recipient will fall within one of the established categories of fiduciary, say trustee and beneficiary or company director, in which event this is a non-issue. But if the recipient doesn't belong to those established categories, it's now clear that nothing short of a fiduciary duty will do. fourth and finally, before Hopcraft, there was a suggestion that it might be possible to use CPR 19.8, which allows representative proceedings to be commenced on behalf of a class to be used in bribery claims. So there was a case decided in the Court of Appeal by Lord Justice Newgee, in which I think what had happened was that IP firms pay commission on renewals, and that commission is not disclosed. And someone brought a representative claim saying, all I need to prove to access the special remedies for bribery is the existence of a contract with the IP firm and the fact that the commission was undisclosed. I don't need to prove any fact beyond that. So it's suitable for representative proceedings. Now, the case doesn't, because it didn't need to decide that point in terms. But if one thing is clear from Hopcraft, it is that these claims are more fact-sensitive than they were previously thought to be. And the more fact-sensitive a claim, the more individualized it will be. You need to look at what happened to each particular individual, and the less suitable it's likely to be for CPR 19.8. There will be other implications, but those are four that I wanted to identify. We're happy to take, unless you...
We're very happy to take questions. Before, again, I just want to pause to go back to one of the points that Niranjan made, which is about restitution for wrongs. I mean, I confidently predict that will go to the Supreme Court in a different case, because that has very serious implications. What they needed to do, just so we're clear, is try and justify the fact that in a tort claim in bribery, so not a fiduciary claim, they were giving a remedy in circumstances where no loss had been suffered. Now, if you don't get it's not a conventional tort claim, because ordinarily in tort you need damages to have been suffered. But here there was no damage suffered, nor was there any basis for a conventional restitution claim, because if you looked at it, there was not an unjust enrichment at all. The point that Niranjan has made is that the only thing left was restitution for wrongs. That's to say, restitution as a response to a tort. Now that is very wide potential implications. Previously, it was thought that you could only get that remedy where the tort involved a breach of some proprietary right, and that makes sense. But they've done away with that. And they basically allowed for the possibility of a general recognition of a claim for restitution for wrongs without the need for proprietary rights. And that is going to come back and not bite them, but it's going to lead to all sorts of arguments in all sorts of fields. And that ultimately is going to have to go back to the Supreme Court, and then who knows what they'll do. Anyway, questions?
On the restitution for wrongs point, one of the key steps in the reasoning seems to be that this isn't a conventional unjust enrichment claim, which is why you can't get restitution. Let's say that I pay a bribe to your agent, which then convinces the agent, which then convinces the agent to have you enter into a contract with me where you purchase something from me. I don't see why you couldn't conceptualize that in terms of just ordinary reasons for restitution rather than restitution for wrongs, being that in that situation, you've paid me more than what I was entitled to, and we take the sum that I paid as a bribe to your agent to just be an overpayment, which is then liable to be returned, which then to me seems to fix the problem of trying to get into restitution for wrongs, which is simply to say that the consideration that I've received on the contract is more than what I was entitled to, and so pro tanto it's liable to be returned as an overpayment.
Yeah, I see what you mean, but there are probably two difficulties with it. The first is if you take the motor finance example. So let's say I pay £100 for a car and the commission is £10 and I borrowed it. There will always be a contract under which I borrowed the £100, and that £100 was in fact payable under the contract. And the hypothesis is you haven't rescinded that contract, so the money was in fact due. And it's generally accepted after, I think it's Barclays Bank and SIBS in the 1980s, that if a particular payment is due, then unless you set aside the basis on which it's due, you can't then bring an unjust enrichment claim. So that's one problem with it. And there's a case called Logic Rose where Mr. Justice Millett says in terms that you can get this particular remedy in the law of bribery without setting the contract aside, which is difficult to reconcile with the opposite rule in the law of unjust enrichment.
In fact, he says you can't set the contract aside.
Yeah, and in fact, he says you can't set the contract aside. I mean, the Supreme Court didn't need to grapple with it because none of this arises if you treat it as restitution for wrongs. But the second problem is there will be cases in which there's no enrichment. Mr. Justice Calver gave some examples of this in the Supipat case. So say I offer you a bribe, but in the event I don't pay it, but the contract is entered into anyway. Or I pay a bribe, but the defendant, because they make a bad bargain, aren't in fact enriched. They haven't inflated the price. But the presumption is irrebuttable, so it wouldn't be open to the defendant in those cases to say I wasn't in fact enriched, which suggests that the true explanation for this rule doesn't lie in unjust enrichment, but in something else.
How did the Court of Appeal get so wrong?
So to be fair to this Court of Appeal, I mean, why should one be? But to be fair to them, they felt that they were bound by Wood, which was in a slightly different context. The problem really did start with Wood and this notion of a disinterested duty. But again, to be fair to them, once you start saying that bribery exists as a tort rather than just inequity, and you're delinking the remedy from equitable roots. Once you do that, then you start thinking, well, if this is no longer in equity but in tort, then we don't have to find a breach of fiduciary duty, because fiduciary duty it's not relevant in tort at common law, it's only relevant in equity. And so what starts happening is the court says, in Wood says, well, we have to find a tort analogue, common law analogue, to a fiduciary duty. And you don't need a fiduciary duty because it exists as a tort in common law. What might be a useful analogue to a fiduciary duty? What about this thing called a disinterested duty? And obviously, if you go back and you look at all the authorities, anywhere where there was a fiduciary duty, there's obviously also going to be a disinterested duty. So you delink, as soon as you delink equity and the bribery, and you start looking for the common law analogue, you're on the wrong track. And you arrive at a situation where you have some new notion of disinterested duty. So that happens in Wood. You get to this case, and you can accuse the Court of Appeal here of being a little bit unthinking, in the sense of, stand back and reflect for a moment as to whether you really think a car dealer is something equivalent to a fiduciary duty to a punter who comes in to buy a used car. I mean, it is a little bit absurd, but you can see how they were led to that by the reasoning in Wood.
Yeah.
I think it may be that I'm missing something. But as regards the public policy justifications for retaining common law tort, if you require the existence and breach of fiduciary duty in order to get into the tort, what is the tort doing that the no profit rule and the no conflict rule don't achieve?
Well, that was our submission. We said you could not find a single circumstance in which getting rid of the tort would lead to a remedy where there ought to be a remedy. And that's a slightly tricksy formulation, but our thesis was you ought not to get a remedy if you haven't suffered some kind of loss. But as soon as you'd suffered some kind of loss, there were other common law claims which were available, possibly conspiracy to injure by unlawful means. There was, however you looked at it, it was impossible to find a circumstance. And no one actually challenged us on this. No one said, well, we can find a circumstance in which there ought to be a remedy and there isn't. But the presupposition is that our presupposition, or our submission, was that there ought not to be a remedy if you've not suffered any loss at all. And if that is the position, you will never find a situation in which the person doesn't get a remedy. So you're not missing something. There is a big problem here.
I agree. I mean, I think the only circumstance in which it could make a practical difference is if you did not have the common law tort and money is paid to somebody who is a fiduciary, and you claim against the payer, that is to say the briber. The claim would lie in dishonest assistance, for which you need to prove dishonesty, and you wouldn't have an irrebuttable presumption of either loss or gain. You'd have to prove it. Whereas if the common law tort, you don't. But that goes back to Laurie's point, which is there really an anomaly if your remedy is only available in cases where you have in fact suffered a loss, or there has in fact been a gain and there's been dishonesty?
And actually, sorry, but you can see I don't like losing these battles. You're dealing with someone who has not been dishonest at all. I mean, if they have been dishonest, get a remedy against it, but the common law allows remedies. But these cases, certainly the car dealers had no idea that they were fiduciaries or had any sort of duty of that kind. And certainly the finance companies didn't, because this had been the law for 75 years. So you are imposing that kind of remedy on someone who's literally properly innocent.
Yeah.
In terms of fiduciary duty, if we're looking at a situation where we've got a broker that wears one hat to someone that's not selling something, and we don't have an express undertaking by them to act within the binding, so we're looking at purely whether it can be implied. Have you got any guidance on what we should be looking at in terms of how and when that kind of duty should be arise by implication?
It's a very good question. The answer is that it's fact sensitive. And what is clear is the test. So it seems from para 10 of Hopcraft that the test is one of necessity. So it's not enough to establish that it would be consistent with the job they are doing for them also to be fiduciaries. You would probably have to establish that they could not do the job or sensibly do the job they've agreed to do unless they are fiduciaries. And I suspect that will in practice require some form of communication which gives rise to a reasonable expectation of altruism, or something in the contract, as you had in Wood, which I think said that the broker would act for and on behalf of the claimant, or words to that effect. But absent that, it may be that there's no duty. Now, the reason why this is probably going to require at least a trip to the Court of Appeal, if not another one to the Supreme Court, is that you have 2 or 3 cases where independent credit brokers, that is to say people wearing one hat, have been treated as fiduciaries, and those cases have not been overruled expressly, and probably not by implication either in Hopcraft. It's just an open question, now that they've told us what the test for fiduciary duties is, whether you need to look again in the light of that test at the one hat cases, and that's probably a task for the appellate courts. Yeah.
Sort of linked to that question, and sort of taking it outside of credit broking.
Yeah.
Thinking very much of the expert tooling cases and
Yeah.
as potentially that sort of grey area. How does this sort of interact with the law of the principles around agency and the way in which sort of agents have straddled the sort of established categories of fiduciaries and the more sort of ad hoc fiduciary duties?
Yeah, so agency is a very good example because it's one of the most difficult relationships to fit within this framework. If you look at the old authorities, late 1800s, the tendency was to treat all agents as fiduciaries, and in the classic textbooks, Finn, Seeley, that's generally their treatment. But the modern authorities say it all depends on what the contract says with the agent. And before Hopcraft, the leading case where the judgment was given by Lord Briggs and Lord Justice Hamblin, as they then were in UBS, it rather suggests an agent is not automatically a fiduciary. You need to look at the contract. In Hopcraft, they say agents are fiduciaries, but only if that's consistent with the particular contract in their case. So I think what will likely be the position is that if you have a true agent, that is to say somebody who's undertaken a role that's been recognized for a long time as agency, they will probably be regarded as fiduciaries for this purpose alone, no profit, no conflict, but not necessarily for wider purposes. And that would then mean they can't take a bribe, or if they did, that the special remedies are available, but that they don't come under the wider obligations that a fiduciary in the full sense has.
That's slightly circular. But one way of just sort of testing that is you get a number of agents, travel agents, estate agents, who everyone knows have a self-interest in doing what they're doing. No one expects a travel agent not to make some sort of profit. But in some senses they are agents for you, and in a lot of senses they're agents for you. They're acting on your behalf in a number of respects, and so too an estate agent. But and in some respects you may say that they do owe a duty of utmost loyalty and not to make a profit, but in other respects they don't. So even within that kind of conventional agency relationship, you have to ask about the particular thing they're doing and whether in relation to that particular thing they were agent in the fiduciary sense, as opposed to simply being an intermediary who's going to charge you.
Yeah.
One of the starker things in the Court of Appeal's judgment was quite quickly they were prepared to make a finding of dishonest assistance. Did you think that would that come at all in the Supreme Court?
Sorry, I didn't catch the last part.
Did you think that the Supreme Court qualifies the reasoning behind the dishonest assistance sufficiently?
I'm not sure the Supreme Court has qualified. I mean, they applied the same test for dishonest assistance. I think it just fails at a prior stage, which is that if there's no fiduciary duty, then there's no claim in equity anyway. So the question of dishonest assistance doesn't arise. On the internal logic of the Court of Appeal's judgment, which is you don't need a fiduciary duty, something short of it is enough. Although they then went on to find they are also fiduciaries, car dealers. And then one of the difficulties about the Court of Appeal's judgment is they don't deal with what you need to know in order to be dishonest. In other words, is it enough that you know that the dealer is a dealer, which obviously you know, or do you need to know that the dealer is under the disinterested duty, or at least the facts which give rise to the disinterested duty? Because normally you need to know the facts which make something unlawful, or and the Court of Appeal didn't make findings about that, but it didn't arise in the Supreme Court in view of the fact that the claims failed at a prior stage.
One more question, perhaps, if there is one. Otherwise, yeah.
In terms of level of disclosure, and obviously the court didn't need to go into what constitutes fully informed consent and what all material facts are because it didn't arise. So it seems to me we're kind of left with a couple of options in terms of what people need to disclose if there is a fiduciary duty. We've got expert tooling, which is currently there as a Court of Appeal decision. That's on appeal to the Supreme Court. They set out a fairly long list of the things that they thought would constitute all material facts, but we'll also have the Court of Appeal decision in Hopcraft, which obviously the Supreme Court haven't overruled because they didn't need to look at that point. I'm just wondering what your take is on how we reconcile those two positions now, and whether the Court of Appeal list, that very long list that it gave, still has any standing, and whether that's going to be persuasive in the future.
Yeah. Do you agree?
I'm not going to answer that because I'll be absolutely honest. I only focused in this case on the things I had to argue about, and so, which were enough. I mean, in effect, though, so the other thing you need to understand about what happened in the Supreme Court is I think they confined us to a day and a half, some ridiculously short period of time.
Yeah, we were told
we were saying you need 4 days for this. And the consequence of them cutting us down, I can't remember how many, was it 2 days or a day and a half?
But for us it was about
day and a half. There were a lot of things which were not properly aired. Dishonest assistance was one of them, actually.
Yeah.
Didn't really get the run it should have had. And as I say, I think Mark Howard had to deal with the disclosure of commission or the level of disclosure, so I let him deal with it. So Niranjan will have to tell you what that was about.
I think the answer is that you always have to disclose the facts that are material, and what is material now depends on what the Supreme Court has said. So the Supreme Court has departed from Herstanger, which was the previous Court of Appeal case, the so-called halfway house. What the Supreme Court has said is the only defense, if there is a fiduciary duty, is informed consent. So it's not enough to tell them, I may receive a commission. It's probably not even enough to tell them, I have received a commission. You probably need to tell them what the amount is, and you need to do it sufficiently clearly that it's not in small print. But beyond that, it's probably going to turn on the facts. It'll depend on the circumstances in which the commission was received, how much time elapsed between the original contract, which may have contained some kind of warning that you may get commission, and the actual receipt of the commission, and what, if anything, you said thereafter.
And just to put that into some context, I mean, that sounds burdensome. But if you're only dealing with proper fiduciaries, it seems fair enough. As soon as you take it outside the proper fiduciary area to, as it was, disinterested duties, then it seems slightly unhinged. But I think in the context of the just dealing with proper fiduciaries, that seems entirely appropriate. All right. Thank you very much. I think that's all I think we're going to say now, because people obviously have to get on with their days, including me. But I think we are...